you'll be able to ask them about the cases, about what it takes to become a lawyer, why they wanted to be a lawyer, anything. The floor is wide open. The judges will come back out after the second Q&A with the attorneys, and they'll answer your questions too. They'll be a little more restricted in what they can talk about, though. They can't talk about the 2 cases, and they can't talk about any other cases actually before the court. But other than that, the floor is wide open. So at this time, please shut off or at least silence and put away any cell phones or anything else that can make noise. And during the arguments, when an attorney is here presenting an argument to the court, no photography is allowed except for 2 cameras that have been authorized, the big one up there and the school paper here. Other than that, again, just want you to keep in mind, this is the real thing. So the parties behind these 2 cases are really counting on you guys to allow the court and to allow the attorneys to devote their full attention to these cases. So with that, I'm going to turn it over to Mr. Finnestead, and he has a few remarks for you.
Good morning, students, and good morning, community members. I'd like to take this opportunity to welcome you all to Silver Creek High School. And over the course of about the last 6 months, we've had this terrific opportunity to work closely in hosting today's event. And that being said, it is an honor for our school to get to do this. It truly is a once-in-a-lifetime opportunity for our teachers, let alone our students, for our school to be involved today. That being said, Colorado Courts in the Classroom was established some 30 years ago. The Courts in the Community program was developed to give Colorado high school students and you rafters an opportunity here for insight into the Colorado judicial system and illustrate how disputes are solved in our democratic system. And these are not mock proceedings, as John went over a moment ago. This is the real thing, and this does not need to be the first and last time that a Silver Creek student was held in contempt of the Colorado Court of Appeals. So students, this morning, we request your utmost attention, all right? And as he said, please make sure that all electronic devices are stowed out of the way and are turned off. Today wouldn't have happened without one of our teachers who's taken the lead on this, and I'd like for all of you to join me in recognizing Mr. Cochter for his efforts to bring today to fruition. I'd also like to thank all of our students, all of our staff members, and our social studies teachers especially for your support of our government students over the course of the last month here and preparing them so that they could be well adept with the proceedings that will occur today. Also, we had some pro bono legal support from a few attorneys within the community, and I'd like for them to stand and be recognized as long as they're here. I know that Carolyn Kurt is here. Ladies and gentlemen, let's welcome Carolyn and appreciate all that she's done. And also Scott Oliver. Is Scott with us this morning? Scott may have not been able to make it, but he's done a wonderful job in presenting this to our students and helping us out. We also have a list of dignitaries that I'd like to share with you this morning, and they have been instrumental in allowing for us to engage in today's event too. The Chief Judge of the 20th Judicial District, the Honorable Maria Birkenkotter. Also joining us, the Honorable Judge John Daly. The Honorable Judge Robert Hawthorne. And the Honorable Judge Craig Welling. Joining us in representing the Colorado Court of Appeals is Jay Strandiford, Brady Grassmeyer, Polly Brock, and John Sarche. Representing the Longmont City Attorney's Office and joining us today, Eugene May. And joining her, Teresa Tate. With the support of our St. Vrain Valley School District Board of Education, as well as our central administration, we're able to host today's events, and I'd like to thank them for their support of this event. St. Vrain Valley School Board member, Deb Lammers. St. Vrain Valley School Board member, John Ahrens. And St. Vrain Valley School Board member and representative to the Silver Creek area, Dr. Richard Martyr. I'd also like to thank Area Assistant Superintendent for the Silver Creek Feeder and Area 2, Dina Perfetti-Bean. And Dr. Don Haddad, Superintendent of Schools, was here this morning. We'll be stopping back in throughout today's proceedings, and I'd like to thank Dr. Haddad for his support of this event as well. Once again, thank you to our students, thank you to the Colorado Court of Appeals, to our legal team that supported us throughout the course of this. I'd like to once again welcome you here to Silver Creek. I hope that today's events are enlightening and certainly an opportunity for all of us to engage in the democratic system here within the United States and the state of Colorado. And it's my pleasure at this time to introduce the presiding judge over today's events, the Honorable Craig Welling.
Good morning, everybody. Welcome. Thank you, Principal Finistad. We are honored to be here today at Silver Creek High School and have the opportunity to do this. As your principal mentioned, we've been doing courts in the community for nearly 30 years. And 30 years ago, I was actually probably among you as a high school student at that time. And this is a great opportunity for us as the Court of Appeals to actually get out into the community. I know that the principal mentioned what a big deal this is to have come to your high school, but honestly, it is a great privilege for us to be able to get out in front of such enthusiastic students and actually share the real work of what the court does with students. We love these opportunities to come out and hold a session in the community, so it's a great privilege for us. I want to extend a special thank you to David Cochter and the other members of the Social Studies Department. Well, those of you who are students who are enjoying the end of your summer, members of the Social Studies Department met with myself as well as two lawyers to talk about today's proceedings. We'll talk a little bit about what our court does, as well as prepare them to prepare their lesson plans for you so that you would come to this prepared. And they were engaged and enthusiastic, and I really want to thank their engagement in this, because without their dedication to this program, it wouldn't be what it is, and so thank you very much. I also want to recognize the two attorneys that participated in that process, Trevor Willard and Jeremy Beck, who volunteered their time to familiarize themselves with the cases that we're going to present today in order to help teach the teachers. And I really appreciate the work that those attorneys did. I would like to also acknowledge the members of the city and county governments that are here today, that are joining us today, as well as the St. Vrain School District, who were so welcoming and did so much work in setting this up. I want to take a couple of minutes to explain what you're going to see this morning. When myself and the two other judges take our seats behind you, or behind where I'm at right now, I'll be sitting in the center, and to my right will be Judge John Daly, and to my left will be Judge Robert Hawthorne. The cases that were selected today to be presented were selected with some care, and we were hoping that they'll be of some interest to you. But like the other cases that come before our court, they raise important legal questions that may be unresolved in our state trial courts. And so the two cases that you'll be hearing about today, in the first case, a man has asked us to review his conviction on a charge of menacing. And the second case brings up questions about the circumstances in which the prosecution may request a delay in trial and the defendant's speedy trial rights. The attorneys in both cases have submitted written, detailed briefs explaining their arguments and why the decision in the trial court should either be affirmed or reversed. Today, they get one last shot at trying to persuade us to go their direction. Our opinions in these cases could help trial judges all over the state of Colorado in making decisions on when similar issues arise in their courtrooms. Now I'm going to go ahead and turn the microphone over to Judge Maria Birkenkotter. She is the Chief Judge for the 20th Judicial District. She has been on the bench for more than 11 years, and today is her second to last day as a judge as she heads into retirement. But it's a great privilege to introduce Judge Maria Birkenkotter.
Thank you, Judge Welling, and I can't think of a better thing to be doing on my second to last day as the Chief Judge in the 20th Judicial District. I also want to thank Silver Creek High School for the opportunity to be here and talk to you. As Judge Welling mentioned, I'm the Chief Judge in the 20th Judicial District. The 20th is a very busy system of trial courts. There are 16 other judicial officers in our district and roughly 200 staff members between courts and probation. In the last fiscal year, we heard about, or at least were filed, about 27,000 cases, to give you a sense of the volume of the work in the 20th. When I talk to folks, I always like to know who I'm talking to, so I'm going to get off the script for just one moment here, and that is I'm going to ask, how many seniors? Raise your hand if you're a senior. Got it. Raise your hand if you're a junior. Oh, wow. Wow. Okay, any sophomores? All right. Any freshmen? Got it. All right. How many of you want to be lawyers? Okay. How many of you want to be judges? Oh, come on. It's a great job. All right. So what happens in the trial courts, and the thing I'm really here to talk about is the difference between the trial courts and the appellate courts. What you're about to see is an appellate argument. I sit in a trial court, and the trial court is very different. In the trial court, the plaintiff and the defendant are almost always present in the courtroom. In the Court of Appeals, the parties typically often don't attend hearings. In a trial court, witnesses testify about what they know, and attorneys try to present other evidence about their client's actions. That doesn't happen in the Court of Appeals or in front of an appellate court, whose job it is to make sure that the law was applied correctly to the facts that were gathered in the trial court and to review the decisions that the judge made. Put another way, the Court of Appeals reviews the work that happens in the trial courts. Was I right? Right? Was I right in some ruling that I made in some case? You'll also notice that there's no jury present here. And at the end of the arguments, you'll see that the court doesn't issue a ruling right away. They take matters under advisement, and that can take weeks or more before they actually issue an opinion. During a trial, the judge often has to make very quick decisions concerning matters concerning evidence, jury instructions, and a wide variety of other matters. Members of the Court of Appeals, in contrast, are able to take, this says all their time. They might disagree with that a little bit, but they have much more time to review those decisions in light of all of the law that we all live under. The ultimate goal is that both parties in a case feel that they've received a fair and equal treatment by the court, even if ultimately one side isn't happy with the final outcome. Thank you all again for bringing the Colorado Court of Appeals to Longmont, and thank you so much to the Court of Appeals for helping educate people all around the state about how our system of justice works. We all hope that you enjoy today's program. We appreciate the time that you've put in and the time that members of the community have put in to being prepared, and I believe that our judges are ready, so please be quiet, make sure those phones are off, and please be attentive so the arguments can begin. Thank you.
much, and good morning, everyone. The first case that we're going to call this morning is People v. Roderick, 14 CA 474. Counsel ready?
Yes, sir.
Okay. And have both sides had an opportunity to review the procedures for this morning's argument?
Yes, sir.
All right. One thing that I am going to remind counsel of is that these arguments are being broadcast on the internet and will also be archived on the court's website. So any sensitive information that you do not want out there, I would ask that you be sensitive to that when you make your arguments. And with respect to this case in particular, as we talk about various witnesses who may be relevant to this morning's arguments, if you would refer to them either by initials or job title or something that describes who they are without specifically identifying them, I would appreciate it. With that said, you'll notice when you get to the podium, I've added an additional minute to each of your time. What I'm going to ask you to do is maybe take a minute to just set the stage a little bit for the students. As you know, the members of this court have read your detailed briefs and are familiar with the facts, and the students have been familiarized with them to some extent, but that might just be helpful to orienting everybody, and I'll give both of you a minute to set the stage in that manner. With that, are we ready to proceed? Very good. For the appellant. Very good. You may begin. Can everybody hear her? All right, let's do a mic. Where's the microphone on your? Is there a microphone on the?
Testing. It's taped up.
Is it?
Side, and you have to I will do my best. Is this any better? Yes.
All right.
So here today we have a case. This is a self-defense case where two coworkers got into a fist fight early in the morning at their job site. Both people said that the other was the initial aggressor. And what happened in this case was my client was charged with assault and also menacing. The jury hung on the assault count, but ultimately convicted on the menacing count. And sort of what happened with the menacing was after there was a scuffle, my client testified that the alleged victim was on the ground. He wasn't sure if he was going to come back at him and re-engage, so he bumped into a fire extinguisher. He picked up the fire extinguisher just to sort of have something in between himself and the alleged victim as he came at him. And so that's the basis for the menacing with a deadly weapon.
Was there conflicting evidence on that, counsel, indicating that there might have been a separation between the assault and the menacing event?
Yes, Your Honor. One witness testified that my client had gone outside and come back in, picked up the fire extinguisher, tapped the alleged victim on the shoulder, and said, would you like some more, or something to that effect. So that's the conflicting evidence there.
That was the mechanic? I
yes,
forget his name, the mechanic. But doesn't the record indicate that as the mechanic was helping Mr. Churchill clean up over the sink, that's when your client approached with the fire extinguisher and asked, have you had enough, or do you want more, or something like that?
Yes, Your Honor, that was the mechanic's testimony.
And wasn't that testimony also corroborated by I think it was the parts manager or service manager who said he entered about the same time that he heard that conversation going on between the mechanic and Mr. Roderick?
My memory of the record, Your Honor, is that two of the other coworkers did come in, and one remembered my client saying, would you like some more, and the other did not remember that. That's my memory of the testimony, Your Honor.
Okay.
If I may jump into the first issue.
Please do.
So in Colorado, general arguments that a defendant is tailoring his testimony simply because he was present at trial is prohibited. And in the words of Justice Ginsburg, that's because doing so transforms defendant's presence at trial from a Sixth Amendment right into an automatic burden on credibility. and it violates the general rule that you shouldn't comment on a defendant's exercise of his constitutional rights. And here, the constitutional rights, you have the constitutional right to attend trial, to confront witnesses, to testify, you have the right to notice of charges, and you have the right to participate in your defense. So in this case, in rebuttal closing, when the prosecutor said, you know, Mr. Roderick has had the luxury of sitting here, and so he's had the luxury of hearing what everyone else has to say. That's the kind of general statement, not timed to anything specific, that the Colorado Supreme Court has said is not allowed.
Didn't the potential tailoring problem here actually begin long before rebuttal close and began with some questioning of Mr. Roderick, as well as some other argument?
Yes, Your Honor. So one of the first questions, or if not the first question in cross-examination, was the prosecutor asked my client something to the effect of, you referenced reading the witness statements on your trial on direct. And that testimony was something about, well, I couldn't remember when another witness had gotten there. He usually gets there at 6, but I remember seeing in his statement that he said he was at 7 on that day. So it wasn't really a contested fact. I did just mention that, I remembered in his statement he had said something different. So on cross-examination, the prosecutor followed up with that and said, so you read his statement, didn't you? And in fact, you read all the witness statements, didn't you? To which my client said that he had. And my argument is that commenting on your right to look at the evidence against you before trial is just as improper as commenting on your right to attend trial.
Was there any objection either to the testimony or to the arguments of counsel?
No, Your Honor. I do believe that this error is plain, but there was no contemporaneous objection.
Isn't plain error a pretty heavy burden to shoulder? And how would you shoulder it in this case?
So there's 2 parts to plain error. The first is obviousness, and the next is whether it's substantial. As to obviousness, the Martinez case from the Colorado Supreme Court had come down, I believe it was 3 years prior to the trial in this case. So that had been the law in Colorado for some time. The judge should have known that and should have been able to cure that problem without benefit of objection. And the general rule that you shouldn't comment on a defendant's exercise of the constitutional rights, that's been a long-standing rule. You know, the cases I cite in my brief go back to the 60s. I believe it's potentially even prior to that.
But here the line's not so bright because there's proper tailoring, a proper tailoring argument and improper tailoring argument. And one is when it's based on a specific inconsistency or the door has been opened to it versus just a generic tailoring argument. So just because there's questions about that doesn't necessarily alert the judge in the same way that a comment on the defendant's silence or failure to testify or exercise of other constitutional rights may trigger a trial court judge to intervene without the aid of a contemporaneous objection. Isn't that the case?
That's certainly true that there is specific tailoring arguments can be made. I would point out that the prosecutor's questions here are almost identical to the ones that were held in Proper and Martinez. And also just looking at the words that the prosecutor used should have put the court on notice of that, saying, you know, it was his luxury to sit here and attend trial. And also the fact that that statement was made and while the prosecutor said, you know, the defendant, of course, is biased in working around the facts, and we're going to go through that. But then the prosecutor, in fact, never did go through that. Just gave a general summary of what Mr. Roderick had testified to, but never pointed to anything in the record to indicate that he had changed his testimony after listening to any of the witnesses testify or after looking at discovery for that matter.
And Mr. Roderick hadn't given any statements to, had Mr. Roderick given any statements to police?
He did, Your Honor.
So, I mean, this is that's the very sort of circumstance where a tailoring argument may arise, is that now that we're at trial, you've changed your story that you gave to police. And that's a specific tailoring argument that would be permissible, right?
Yes, Your Honor. So if they had given one account to the police after listening to witnesses, you know, there was something different, and then at trial they had testified to sort of conform to what the witnesses had said, that would be a specific tailoring argument.
But no such instance of that was raised on cross-examination or from any other witness, is that right?
No, and in fact, Mr. Roderick's testimony was consistent the entire time. The statement he gave to police was not, it wasn't in great detail, but he had been claiming self-defense from the beginning, saying that the alleged victim had sworn first.
Counsel, how was he prejudiced in this case? Remember, it's got to be even a type of a serious type of prejudice to qualify as plain error.
Yes, Your Honor. And so this is an attack on my client's credibility in a case where credibility is absolutely key. This is a self-defense case where my client testified. He is the only witness really testifying to those version of events, so his credibility is of the utmost importance. And an attack on that is could be extremely harmful. And also just the use of the word luxury, it implies that this is my client's constitutional right and his statutory obligation to be present. It's not a luxury for him to be there.
Is it a per se rule you're arguing for? If it's an adverse comment on a credibility, it's per se reversible error under the binary rule?
No, Your Honor, I'm not saying that. I'm saying that it still needs to meet that the burden that it was substantial, and I'm arguing that here it was. Because of the facts of this case, that it's a self-defense case where my client's credibility is so crucial. And I think...
And they believed, or at least believed him enough to find, for some of the jurors, reasonable doubt on the question of self-defense, insofar as they hung on the self-defense count. So how does the fact that they hung on one of the counts but convicted on another play into our analysis of the prejudice prong, or the impairment of substantial right?
Right, so this was a close case. The jury thought it was a close case. And had it not been for this improper attack on my client's credibility, they might have acquitted or hung on the menacing count as well. So I think particularly in these facts where my client's account of his self-defense was fairly convincing. I mean, the alleged victim was a Golden Gloves boxer, and he was bigger than my client. He bragged about getting drunk and getting into fights. And so all that taken together, I'm convinced at least some members of the jury that he probably swung first. And had there not been that improper attack on his credibility, they might have also believed that when he picked up that fire extinguisher, he did that as a further act of self-defense and not as medicine.
Do you want to turn your attention to the evidentiary issue at all?
Yes, Your Honor. I can move there now if there's no further questions on the first issue. So the second issue, again, this is a self-defense case. Two workers got into a fight first thing in the morning, and they're both saying the other is the initial aggressor. Now, one of those people there's testimony that there would have been testimony that he came to work intoxicated more often than not, and that evidence was kept from the jury.
And you contend it should have come in as habit, correct?
Yes, Your Honor.
Is habit more often than not, or is it something more than that? Do you have a more often than not example of qualifying as habit or routine practice?
So I don't, Your Honor, and that's looking at the cases. It depends on what the habit is for the courts to determine whether it's enough to cross that line into habit or not. I would say in this instance, going to work drunk more often than not is enough to bump into that line as being a habit. And so sort of the thing that I had thought of, for me, the first thing I do in the morning more often than not is I make coffee. And so I think that would be proper evidence to say that it's my habit to make coffee in the morning because I do it more often than not.
Counsel, let me ask you, you said more often than not may be based on context. Do you have any cases that you cited in your brief about habit being based on more often than not?
I don't believe I have any cases saying that specifically, Your Honor.
And I guess sorry, Justin. No.
I was just going to ask you, the cases cited by the opponent, do they stand for habit means always?
Not that I recall. I can't recall off the top of my head.
I'll ask them.
And I guess I think of habit more along the lines of, I don't know if I did something on a particular occasion, but because it's become so routinized, I did. In other words, I can testify that I ate a ham sandwich on a particular date because it's Tuesday, and I always eat a ham sandwich on Tuesday, and it's my habit. Therefore, even though I don't have a specific memory of it, because it's become so routinized, you can offer that testimony without necessarily a specific memory, as opposed to just, I have a bad character. I occasionally, or even more often than not, come to work intoxicated, and that's, to me, seems like character as opposed to habit.
Right, and that's what the trial court decided in keeping out the evidence. So I think, and you bring up this difference sort of between habit being a behavior that you can testify to, sort of empirical sort of data that you can observe and testify to, versus character kind of gets into opinion, this guy's a jerk, that's a character. I do think that coming to work drunk is more of a behavior. This is something that witnesses can see. They can say, well, I smelled it on his breath, I noticed his behavior, rather than a general sort of assessment of his character. So I do think that this falls more into the observation of behavior rather than an opinion on his character.
And if the trial court did improperly exclude this habit evidence, as you call it, how was your client prejudiced by that ruling?
So again, this is a self-defense case where the credibility is extremely important, and also in self-defense cases, looking at all the circumstances takes heightened importance as well. It would have gone right to the reasonableness of my client's belief that he needed to act in self-defense and to the reasonableness of the force that he ultimately used. It would have corroborated his testimony that the alleged victim was drunk. Again, very important to allow corroborating evidence when a defendant testifies. And it also goes to the alleged victims. It would have supported why, his ability to remember and perceive that day, and it could have helped explain why he couldn't remember much of what had happened. And again, as brought up in the first issue, this was a close case where the jury hung on the first count. Had this evidence come in, had the jury know that one of these two men who got in a fight came to work drunk more often than not, could have gone a long way in helping them come to their decision and acquit my client.
Because he's drunk doesn't necessarily mean he started the fight.
That's something that the jury should have been able to consider when they were determining their verdict.
You think a person being drunk is relevant to having started the fight?
I do, Your Honor.
How about breaking that down for me?
Okay, so sort of when you're drunk, if you're not making good decisions, some people get aggressive when they're drunk, and going straight to the menacing count could have helped explain why even after he had sustained some injuries to his face, maybe he wasn't feeling that and was making rational decisions about continuing that fight, which could explain why my client was still afraid and felt that he needed to...
I thought that going to the menacing count, he was over the sink. He was standing over the sink. So how does the drunk affect the menacing count?
Right, and so that was one witness's testimony against my client's testimony, which is that was contemporaneous with the fight that just ended. And so again, that should have been a question for the jury to decide whose account was correct, and that could help them make a decision. If there are no further questions, I'd like to save my remaining time for rebuttal.
Very good. Thank you very much, Ms. Pitts. Ms. Adams, I'm going to go ahead and extend you the same courtesy of a minute to kind of roadmap for the students. So,
Thank you, Your Honor.
You may proceed.
Good morning. May it please the court. My name is Rebecca Adams. My registration number is 31044, and I represent the people of the state of Colorado. I think it's important to remember in this case that the defendant was charged with two offenses. He was charged with assault and menacing, but the jury only convicted the defendant of menacing in this case. And that's relevant to both of the issues here and whether or not the defendant can establish that he was prejudiced by any of the error that may have occurred. Now I'll begin by addressing the first issue in this case, which is whether or not the prosecutor's closing argument was improper. Now, while general tailoring is improper, specific tailoring is allowed. And as long as the prosecutor cites to an evidentiary basis in the record, the prosecutor is entitled to make a tailoring argument. Now, in this case, the defendant injected a witness's prior statement into his testimony on direct examination, stating that he had read the witness's statement regarding the time that he had arrived at work, and he implied that the witness had been mistaken in the time that he arrived at work. And by extension, this also attacked the credibility of the victim in this case. In closing argument, the prosecutor then...
Excuse me a minute. How did that attack the credibility of the victim?
The victim in this case stated that he went and was making a cup of coffee at approximately 7:30 in the morning when he was attacked from behind unprovoked. The defendant said that the victim was not making coffee, that he didn't even remember him with a coffee cup in his hand, but the defendant said that he did recall seeing a full pot of coffee, despite the fact that, for his testimony, no one else was at work yet that morning. So if, in fact, there was coffee, that helps to explain that the victim was getting coffee at the time that he said he was attacked.
How does that attack on his credibility as opposed to saying, well, he very well may have been completely accurate in that? To me, that seems like a concession that the victim's testimony about when he arrived may well have been true.
I'm not sure.
I guess if the defendant is conceding that he saw that pot of coffee, isn't that more of a confirmation of what the victim testified to as opposed to an attack?
The defendant testified that he believed this particular witness, P.S., that he made the coffee. And he said that that was the case because he always arrived at work at 6 o'clock that morning. And when the prosecutor asked if he arrived before him that morning, he said, well, in his statement, I know he said he didn't get to work until later, but I'm pretty sure that he had to be at work earlier that morning because of when he drops his wife off and when he usually arrives at work.
So are you saying that the defendant changed his testimony from what he had told the police earlier to what he's testifying at trial?
Well, he did in fact change his testimony. There was...
So he did not change his testimony?
No, he did.
Okay.
Separate from this discussion, which the prosecution...
No, let's stay with this discussion. This is the one you think is the tailoring argument that's appropriate, so I want to know if he changed his testimony with respect to this.
No, he did. I don't believe he changed his testimony with respect to this. But that's not the only way that there can be a tailoring argument. In Martinez, they talk about whether or not the tailoring can come from implying that a witness is lying. That can be part of the tailoring argument, and that's what happened in this particular case.
Is there an implication the witness was lying or mistaken? There's a difference.
There is a difference, but I think that that's exactly why this is an arguable point here, because there was no objection to this, and he basically said that he believed that this other witness had been to work earlier than he said that he was, and he had argued that the victim certainly was lying when he said that he was getting a cup of coffee when he was attacked, because he said that's absolutely not what happened and that the victim in fact had attacked him. Now, in closing argument, the prosecution specifically referenced this point of the testimony, saying that the defendant mentioned he looked at P.S.'s statement before this trial. Now, because closing arguments are unscripted, we don't require prosecutors to use some rigid formula in making their argument. As long as there is some reference to the evidence of tailoring, the prosecutor's argument is proper.
But that's not a reference to the evidence of tailoring, that's evidence of looking at a statement. That's exactly the sort of inappropriate comment of just the ability to participate in the defense.
Well, I think that the prosecutor might have been slightly inartful in not tying it completely together regarding the evidence. I think that it was clear to the jury what the prosecutor was referencing here. And we have to remember that in this case there was no objection, so we have to analyze this under a plain error standard of review. And in that case, the defendant has to establish that this error was both obvious and substantial, and that this error so undermined the fundamental fairness of the trial that it casts serious doubt on the reliability of the judgment of conviction. And we simply don't have that here. The error wasn't obvious. While there certainly is case law saying that general tailoring is not allowed, it wasn't that clear-cut in this case that that's what this was. And there wasn't an objection to put the court on notice. Additionally, the defendant was only convicted of the menacing count. The tailoring argument really went more toward the assault, because in the assault case, there weren't any independent witnesses of the assault.
Counsel, he wasn't acquitted of assault, though.
He was not acquitted.
It would be different if he were acquitted, but he wasn't acquitted. There were some jurors who thought he was guilty of the assault and may have been influenced in that, and perhaps influenced with respect to menacing by if the argument was improper, an improper argument.
Well, in making a plain error analysis, we have to look at the strength of the evidence. And I think certainly the strength of the evidence is much stronger in the menacing count than it was in the assault count, because we did have independent witnesses. We had an independent witness who witnessed the defendant leave the room, come back, pick up a fire extinguisher, touch the victim on the back, and say, "This isn't over, you want some more of this."
Was there any corroboration of that witness's testimony?
There was another, after the defendant said that, this particular witness had told him, this is over, put it down. There was another witness who did hear that portion of the conversation where PS told the defendant to put the fire extinguisher down, but there was no one else that heard the comment the defendant made about this isn't over, do you want some more?
So we really have three witnesses that testified regarding whether or not the menacing statement was made, two independent witnesses which were in conflict, and the defendant. So this really does come down to a credibility fight.
Well, the two independent witnesses were not in conflict. It's just that the second witness came into the room after the fact and only heard that portion of the statement. So it wasn't conflicting as if one said it happened and one said it didn't. It was just that one was present for the entire period and one was not.
But there was conflicting evidence between the defendant's testimony and the other witness. And
yes.
So do you, in doing a plain error analysis, do you just pretend the defendant didn't present conflicting evidence?
No, but I think there are multiple factors that the court has to consider. One of them is the strength of the evidence, and you can, of course, look at both the defendant's testimony and the conflicting testimony. You can also look at the prosecutor's argument in this case regarding the tailoring that went more toward the assault count. There was no argument that there was any tailoring made with respect to the menacing count. And again, we have to look at the fact that this was a minor comment in an otherwise proper closing argument. And prosecutorial misconduct in closing argument rarely constitutes plain error requiring reversal. I think it's also relevant to look at whether or not there were specific instances of tailoring that the prosecutor could have commented on but didn't in making this plain error analysis. This is something that the Supreme Court looked at in Martinez in determining that the error in that case was harmless. And in this case, the defendant did make a statement to the court prior to trial and did change his testimony at trial. So again, while that wasn't something that the prosecutor specifically commented on, that is something that this court can look at in making a plain error analysis.
What is that specific change?
The defendant's statement to the police was that the victim swung at him, he blocked it, and then he punched him in the face. At trial, he testified that the victim came up to him, told him, "You're out of here," and shoved him in the face. In the one instance, he blocked it. In the other instance, the victim actually assaulted him. If the court has no further questions on the first issue, I'm happy to address the second evidentiary issue.
Certainly.
Now in this case, the defendant wanted to bring in evidence that the victim was drunk at work, or sick at work, or hungover at work, and that these things happened routinely. In order for something to be a habit, it has to be a regular response to a repeated situation. There has to be this regular practice of responding to a particular situation with a particular type of conduct. But it also has to be relevant. And in this case, the defense attorney was very clear in the trial court that there was no history of violence or aggression between the victim and the defendant. There was no history of violence and aggression on the part of the victim based on his consumption of alcohol. And because of that, the defendant had no reason to believe that he was in danger. And in fact, the defendant didn't even testify that he believed that the victim was drunk on the day of this incident. The only testimony that he gave was that he believed that the victim smelled of whiskey. But he didn't say that he was drunk.
Aren't we cutting hairs a little fine here? You don't think he could have argued to the jury that a fellow showing up smelling of whiskey may have been drunk?
He could have, but he didn't. And in this particular case, there was often comments that the victim, when they were talking about trying to get this evidence in, it wasn't always that he was drunk. Sometimes he was just hungover. Sometimes he was just sick. But again, all of this evidence, none of it went to the real issue here, which is whether or not the defendant responded appropriately in believing that he was about to be attacked and therefore responded appropriately and acted in self-defense. There was no evidence here at all that this particular victim ever responded aggressively based on the fact that he may or may not have been drinking.
Could evidence that he had been drinking have supported the theory that the victim was the initial aggressor?
Not without more, Your Honor.
Tell me
Well, I think in this particular case, and the trial court even it made similar statements when addressing this issue, and the trial court did go over this issue multiple times throughout the trial, talking about whether or not there was any relevancy here. And the court had said if we had some indication that this particular victim was often aggressive or violent when he was drunk, that might be relevant to whether or not he was the initial aggressor here. But the only thing that we have is that he may have come to work drunk on occasion, and that he had problems with his job performance as a result. That has nothing to do with whether or not the defendant responded in self-defense, and certainly not with respect to the menacing count.
What about, well, actually, what about the fact that the defendant may have known about his propensity for showing up intoxicated? Isn't that part of the totality of the circumstances from a subjective standpoint that may help explain how he reacted or give the jury more information about whether his reaction was reasonable based upon his knowledge?
But again, Your Honor, even if the defendant knew that the victim came to work drunk, there was still no reason for the defendant to believe that this victim was violent or aggressive or that he had any reason to be fearful. There had never been any type of altercation at the workplace that involved any type of physical violence with this particular victim.
Couldn't he have argued that a reasonable response may be impacted by whether or not the person on the other side of the altercation is or is not intoxicated?
And the trial court did allow the defendant to argue that on this particular day, the victim, he was able to argue that the victim, he could have argued that he was drunk or that he smelled of alcohol or that he believed that the victim was drunk, and that's why he was responding the way that he was. He was able to make all of those arguments regarding this specific instance on this specific day. But bringing in past instances of the defendant coming to work drunk does nothing to add to this particular instance about whether or not the defendant responded appropriately. There was simply nothing to link that to this particular case.
And so defendant did not comment about the victim being drunk or intoxicated on this particular day during this event?
He did not, Your Honor. The only statement that he made during his testimony that he smelled was that he smelled whiskey on the victim's breath.
Ms. Pitts makes the argument that this case hinges on the credibility of the defendant. Do you see any difference in the credibility issue between and the self-defense argument between the assault event and the menacing event which occurred? It seems to me from the record, menacing and the assault were somewhat separated. Is that right? Because the defendant started taking his tools outside and loading up things. The victim was over the sink cleaning up when the mechanic came in to help him.
Yes.
What difference does that make, if any, on our analysis?
Well, again, I think going back to the tailoring argument and the evidence that was presented there, that really all went to the assault count, which he was not convicted of. There was no argument about the tailoring, which could negatively impact his credibility with respect to the menacing count. And the defendant even admitted that he had picked up the fire extinguisher. No one asked him whether or not he said the words that were attributed to him by the other witness, but he did at least indicate that he had been going back and forth, that he did come back in and he did pick up the fire extinguisher. And then we had an independent witness who stated that the defendant said certain things to the victim at that time. But really, the evidence that's being complained of here really went more toward attacking his credibility, if that's what it could be called, with respect to the assault count.
And how do we know that?
I see my time is up. Would you like me to
You can go ahead and answer this question.
Again, I think the reason that we know that is because with respect to the assault conviction, we don't have any independent witnesses. We only have the defendant and the victim's testimony, and the victim didn't remember very much, and the jury couldn't reach a verdict on that particular case, which shows that, at least with respect to some of the jurors, that they did not view his credibility in a negative manner and did in fact believe him with respect to that count. The menacing count occurred later. There were independent witnesses. It was a completely separate event, and there was no argument that the defendant tailored any of his testimony.
Very good.
Do you ask one more question? The tailoring comment, wasn't that directed towards the independent witness or tailoring around the independent witness's testimony?
Yeah, PS was the same. No, PS was the one that he commented on in his tailoring. The witness, it was LVH, was the witness who testified regarding the defendant's statements to the victim for the menacing count.
And who had seen him approach with the
Fire extinguisher. Yes, that was LVH. PS was the other witness.
But PS was sort of the corroborating witness to that, or potentially corroborating witness.
Well, what all PS heard was that LVH told the defendant to put down the fire extinguisher, which the defendant admitted he was holding.
Or put down something. I think it was, he
Put it
said,
down.
he said, I think it was a fire extinguisher.
Right.
I don't know.
Yes, but the defendant did admit that he was holding the fire extinguisher.
Very good. Thank you very much, Ms. Adams. Ms. Pitts, since we went over a little bit, I'm going to add an additional minute and a half to your time in addition to the time that you had reserved.
So just a few quick points. I do want to mention the inconsistent statement from his statement to law enforcement at the time versus what he said at trial. His statement at the time was the alleged victim swung on me. And at trial he testified, well, he kind of came up to me and shoved my head back and got in my face. He was cross-examined on that inconsistent statement and sort of explained, well, I sort of meant it as one and the same. But I just wanted to point out that he was properly cross-examined where there was that inconsistent statement. I did want to mention that in Martinez, when there are inconsistencies that potentially could be tailored, I don't actually think this is tailoring because there wasn't. He wasn't changing his testimony based on the alleged victim's testimony, for instance.
But didn't the Martinez analysis go down that road on a plain error analysis to say, well, even though this was improper generic tailoring, because there was evidence in the record that could have supported a tailoring argument, that goes into the plain error analysis?
Yes, Your Honor. That when the prosecutor does not actually specify what the tailoring was, then that doesn't go to the error, that just goes to the harm. And then for the second issue, I just wanted to clarify that the offer of proof was that there were 4 witnesses who were going to testify that the alleged victim showed up to work intoxicated, and it was 1 witness that was specifically going to testify that it was more often than not. But I just want to...
And wasn't that essentially being offered as classic propensity evidence? In other words, my client has testified that he was intoxicated on this occasion, and now I'm going to bring in a bunch of witnesses that says he does that a lot, and what we want the jury to infer is, on this occasion, he was acting in conformity with his bad character trait. Isn't that classic propensity?
Yes, Your Honor, that's what the Rule of Evidence 406 does. It says that when there's a habit, when there's this observed behavior, that actually is evidence that you conform with that behavior on this particular instance.
As long as the predicate for habit has been established, right?
Exactly.
Which is where the swords cross. Okay.
If there's no further questions, I would respectfully ask you to reverse Mr. Ardrick's conviction.
Very good. Thank you, counsel. Court would like to thank both lawyers for their excellent briefing as well as their excellent arguments here this afternoon, and also acknowledge that the fact that you sacrificed to come out here to participate. This program only works when we also have lawyers that are willing to make the trip out here. And I know both of you actually work in the building where the Court of Appeals is, so coming out to Longmont is something I want to recognize and thank you both for, and your excellent arguments this morning. With that, the case will be submitted, and an opinion will enter or issue in due course. With that said, we're going to go ahead and take a brief recess. I think you'll have an opportunity to talk to some of the students while we're deliberating the case, and then we'll be back in a little while to hear our second case. With that, Division 2 will be in recess.
All rise. Court will be in recess.
Okay, ladies and gentlemen, this is your chance to ask questions about the cases if you like. As I mentioned before, the floor is wide open. Ms. Adams and Ms. Pitts are gracious enough to spend a little time with you. So we've got a microphone here. If there are questions, we can get students to line up at the microphone and ask. I know it's always hard to be first. Does anyone have a burning issue they want to ask about?
Hi, I just wanted to know what tailoring is.
I guess we should have explained that, right?
So tailoring really is if it's really just that the defendant listens and hears witnesses testify and decides to change his, what he had said prior based on that testimony.
I was just wondering, were you the original lawyers on the original case or just an appeal lawyer?
Just the appellate lawyers.
Yeah, we're the appellate lawyers.
This is mostly for Ms. Pitts. I was wondering, I read in like the case write-up in the brief that you wrote that there was a witness testimony that in fact the victim showed up and was violently drunk on more than one occasion, and I was just wondering, how do you choose to leave information out like in your rebuttal, or like how do you decide what is the most important versus like something that doesn't need to be put in there?
Are you asking why I didn't? Well, so the offer of proof below didn't include that he was violent when he was drunk. Perhaps that could have been elicited if they were allowed to go down that road with those witnesses.
Okay.
Am I answering your question?
Yeah, I think so. So it's like the difference between like elicited or like, I guess my real question is like, how do you decide what you say in your rebuttal?
Hear an argument?
Yeah, like.
Oh, well, you have 2 minutes and it's sort of what are the most important points I need to get to.
Okay. Thank you.
Yeah, thank you.
Might I just ask first how long you two have been working in law?
I have been an attorney for 18 years.
Wow.
I've been doing criminal appellate work for 17.
Amen.
I'm in my 4th year of practice and 2nd year as a public defender.
Okay. As someone that wants to go into a lawyer, I just wanted to know how many years it took you guys to get used to being interrupted during your speeches.
I think you get used to that right away. That's pretty common. And this is a particularly active court because all of you are here. Sometimes when we do our arguments, we get very few questions from the court. But I think, at least for me, I much prefer to have an active court who's asking a lot of questions because what I want to do is answer those questions. So if the court doesn't let me know what it's concerned about, it's hard for me to make those points. So I love an active court. I don't look at it as an interruption.
Okay. Thank you.
Hi, I'm the attorney that worked with some of the students, and yeah, you're welcome. One of the questions and one of the things that we talked a lot about was what's at stake for the defendants who get convicted and then have an appeal going on. We noticed that this case went all the way back to 2012. So my question is for the defense, if you can comment on how long Mr. Roderick was actually incarcerated, was that suspended, what was at stake for him?
So he spent 90 days in jail and 2 years on probation, but the consequences of a felony conviction last your entire life. They can have immigration consequences, they can affect your employment, your housing. So it extends really for the rest of your life. You lose your gun rights, for instance, and in Colorado you can't serve on a grand jury if you're a felon. So even though the appellate process does take a long time, it's very important for our clients that we continue to fight for their felony convictions.
I just have a question, and this is more of a trial case question. And when it's a case where it's like this, where it's a he said versus he said thing, where they both have two opposing opinions on who started the fight. How does the jury decide which one is actually saying the truth, whereas which one is saying is not telling the truth?
I think that it's really just a credibility determination. It's the same way that you determine whether your friend's telling you the truth or your sibling. You look at all of those things. You listen to the testimony. You see if it's consistent. You watch their body language. All of these things factor into that. From an appellate lawyer.
My question is, how is it decided whether or not evidence should be withheld from the jury?
So the judge is going to look at the Colorado Rules of Evidence, in which, our rules of evidence go back centuries to English common law, which is, what do we think is reliable and what do we think is not reliable? And so, for instance, in this case, it kind of came up that we don't think that character evidence is particularly reliable, that, well, this guy's a jerk, so he's probably a jerk on this day. That we just don't think that that's very reliable evidence. And so the judge, when he's looking at whether to let something come in or not, they'll look at the rules of evidence, and then they'll look at cases interpreting those rules to figure out, should this come in or not? And that's just because sometimes there's just evidence that is just so inflammatory that it's going to sway the jury in a way that might take them away from the truth.
But in most cases, the trial courts have a lot of discretion to decide what comes in and what stays out. And so because the trial courts are the ones that are we give them a lot of leeway to make those decisions. And then we come up here and argue about whether or not they were right.
Thank you.
About a Martinez case a lot. Is that a Supreme Court case, and more about what is it about?
That's a Colorado Supreme Court case that came out in 2010, and it really dealt almost with the exact issue that we're talking about here, this idea of tailoring and what's appropriate argument and what isn't.
Thank
you. With regards to earning a law degree, do you think it's better to go through, say, a public state university and getting a pre-law type of education and then going to good, like, how would you best recommend earning a law degree that's both cost efficient and like effective in earning that law degree?
Law school is great because you don't need a specific degree to go to law school. A four-year degree is great. So if there's a particular area of law that you're interested in, there's something that you think might be beneficial long term, and you want to. I have friends who majored in some science field. They went into patent law, something like that. I was an English major, and so I went to law school. Those are your options for your thinking.
Great. Thank you very much.
So, what made you guys both want to get into law?
So I don't have a great answer to that question. Similarly, I had a degree in psychology and a minor in philosophy, so I didn't have any lawyers in my family. I didn't really know what I was getting into. I'm very lucky that it worked out for me, and I happen to actually love what I do. So I don't have a really great story for that. It just happened to work out.
Yeah, I heard somebody saying something about teacher, and that was actually my first thought. But I'm not sure I can do what you guys do every day. So I have a couple of teenagers who are high school students right now, so bless you. I'm just not sure I quite have the patience for that. So I think this is a little more up my alley. But I always thought that it's really important, just as my opposing counsel was talking about how important it is for the defendants, I think it's really important as well to give a voice to the victims. And that's something that I've always kept in the back of my mind going through law school and throughout my practice.
Gotcha. And you both work specifically with the appeals court, correct?
Right. I work for the Attorney General's office.
Okay. Well, why are you specifically there?
I really love the academic nature of criminal appellate work. We do a lot of research and writing and reading. So if what you're watching on TV is all of this trial work, and that's what you think is really exciting, it probably isn't for you. Because I really do spend a lot of hours in front of my computer. I don't even have clients, so I don't really even talk to anybody. I'm just researching and writing, and occasionally they let me come here and do an argument and talk to all of you, which is great. So.
Yeah, and the same. I love being able to sit down and really just focus on a case for a good amount of time, read the record, and just look at the entire trial and see, what was this a fair trial, and be able to argue that you know, if something really terrible happened at trial, to be able to argue that.
Awesome. Thank you.
So I noticed earlier in the case you said that luxury was not an adequate word to use. Do you spend like a lot of your time nitpicking words you should use? Like, I didn't
Yeah.
Thank you. Hello. I have a question. So obviously, there's a bunch of people here that don't usually go to court because there's a bunch of little teens around, right? So I was wondering if this is much different, or not very much different, or how different it is than a normal courtroom setting.
Well, normally we don't have nearly this number of people watching our arguments. But I think that what you saw is pretty indicative of what we go through with any case. I mean, we're sitting up here with the judges, they're asking us questions, we're trying to answer them the best that we can, and this really is what an argument looks like. It's just on a much smaller scale with fewer people watching everything that we say.
So it's like real life.
This is absolutely real life, yep. Irrespective of all of you.
That's dope. Thank you.
You're welcome.
If you're allowed to talk about this, I was wondering what is the hardest case you've ever had?
I mean, go ahead. I don't even know that I have an answer. Every case is challenging in its own way and hard. There are cases that are hard emotionally and in ways that you don't anticipate. So I don't know that there's one that jumps to mind. You know, there's good and bad and interesting and boring and kind of every case, you know.
That's probably true. I mean, we've had, some of these cases, and, we win or lose here, and we end up in the Colorado Supreme Court, and sometimes our cases go even as far up as the U.S. Supreme Court. So in those cases, it's probably an issue that's novel that we haven't really addressed, so the research is more difficult. But sometimes there are emotional aspects where you get very attached to your client, or you might be the victims, and those cases can be difficult for other reasons.
Do you guys get like assigned cases, or do you have to choose on what cases you work?
Well, for me personally, I get to choose the cases that I work.
Okay.
So we have 3 to 5 attorneys in my office. We handle all of the criminal appeals for the state of Colorado. We're kind of divided up into different teams, and we have all of these cases. And for the most part, we get to kind of pick and choose. We can choose issues that we think are interesting, or that we like, or that we specialize in, or just fact patterns.
So, like, I was just wondering, like, what happens if you don't believe what you're arguing, or if you know that they're guilty or something? Do you have any experience with that?
Yeah. So just to answer your first question first, I get assigned my cases, but as far as what do I think of my client's innocence, that's not my job. My job is to see if they got a fair trial or not.
Gotcha. Okay. Thank you. Good morning. My question for you today is, what inspired you to become lawyers?
Again, I don't really have a good answer to that. I just didn't know what else to do after college, but it really worked out for me. And being a public defender is it's my dream job, absolutely.
Thank you.
Thank you, counsel, very much for your time.
Thank you for having us.
All right. Okay, we'll take a couple minutes to switch up the counsel tables and get ready for the second case, and the judges will be back out in just a couple of minutes.
much. Welcome back to Division 2 of the Colorado Court of Appeals. We're going to hear our second case on this morning's docket, People v. Sinet, 2016 CA 1963. Is counsel ready to proceed?
Yes.
Very good. You will have 15 minutes per side. The appellant will be responsible for managing their time for rebuttal. I am going to add a minute of time to each of your clocks to maybe just kind of ground everybody and give a little bit of a roadmap of the issues. And when I say the background of the case, I'm referring to the procedural posture as opposed to the underlying facts of the case. The other thing I would remind you is that the arguments today are being streamed on the internet as well as will be archived on the court's website. So please be sensitive to that as you make your argument. In particular, in this case, the victim and our missing witness should be referred to by her initials or as the victim or alleged victim, not by name. With that said, does either side have any questions? All right, very good. Then let's go ahead and begin.
May it please the court. My name is Tanya Carey, bar number 41693. I'm a prosecutor in the 4th Judicial District, and on behalf of the people, I represent the appellant. This case centers on a request for a continuance of trial in a criminal case that did not affect the defendant's speedy trial rights. The defendant in this case is charged with aggravated robbery and menacing. The victim of those crimes was served with a subpoena to appear at trial. 4 days before trial, the prosecutor notified the court at a pretrial hearing that the victim had indicated that she did not want to honor the subpoena and appear at trial. The prosecutor also informed the court that the victim was personally served and she would be asking for a warrant, bench warrant to issue. The morning of trial, the victim did not appear. The defense moved to dismiss the case. The prosecutor responded by asking for a continuance short of speedy, pointing out a date within speedy when the case could be heard, and also approaching the court with evidence of personal service and requesting a bench warrant. The issue presented here is whether prosecution, when they ask for a continuance and provide proof that a material witness who is unavailable is under personal service, and also request that that trial be within speedy trial, whether it is an abuse of discretion for the court to deny the continuance and dismiss the case. The people's position is that it is an abuse of discretion, particularly where there is personal service on that witness. Personal service completely satisfies the requirement of due diligence.
Did the prosecution ever ask for a bench warrant to issue independent of their request for a 1-week continuance?
They asked for it right after they asked for the continuance.
But did they say, fine, I understand, Your Honor, that you're denying our continuance, we'd still like the bench warrant?
It didn't play out that way, but I say, looking at the record, the prosecution, in response to the defense request for a dismissal, asked for the motion to continue, and then immediately asked that a bench warrant issue. The court never ruled explicitly on either the motion to continue or the request for a bench warrant.
I thought the prosecution asked for both a continuance and a bench warrant. The court denied it, and after denying it, turned to the defense and said, what are you asking to do? And the defense moved to dismiss the case after the court said it wasn't going to grant the continuance because it didn't think it would do any good. That's my recollection.
And that's not how I read the record of the case. It's the defense asked for a dismissal, and then the prosecution answers with a request for continuance and asking that the bench warrant be granted. Then ultimately the court says that it's going to wait 10 minutes and then it dismisses the case. But I'd argue that the prosecution didn't get an opportunity to readdress that, nor should.
Well, the prosecution didn't even try. It looks like I'm not granting your continuance, so I'm going to dismiss the case. And the prosecution never said, we object to the dismissal.
Because wasn't there a third option available to the prosecution here and say, look, Your Honor, don't dismiss the case. We've already told you not only do we have her under personal service, we know where she lives, we know where she works, we've had an officer in communication with her. If you're not going to grant the continuance, we at least want to go forward with trial, and we want the warrant that we're entitled to, and we'll try and pick her up.
Well, once the court dismissed the case, the prosecution didn't have that opportunity. In fact, asking again that the bench warrant issue, when the court in the first place had never ruled on that request, would really would be redundant.
But go ahead.
Why would the prosecution even object to the dismissal once the continuance has been denied? Wouldn't they have been in danger of their case being placed in jeopardy and being unable to find a witness and therefore having the case dismissed and never be able to retry it?
If I understand the question, why?
What incentive would the prosecution have had to object to the dismissal of the case, to object to the dismissal of the case?
Because the prosecution wanted to continue the case. The prosecution had the witness under personal service.
Let me ask you a different way again. Would the prosecution have wanted to go forward with the case at that point if the continuance had been denied?
If the continuance had been denied and the request for a bench warrant had been denied, the prosecution at that point would have little option, but the prosecution still at that point is attempting to prosecute the case. Getting the witness, a reluctant witness, under personal subpoena, and then having to do that again with a new trial would be even more increasingly difficult.
So you think they should have tried the case right then and there without the witness? You think they should have gone to trial then?
No, Your Honor. I think they should have had the opportunity to get a bench warrant so that they would be able to locate that witness, have the power to bring that witness in, and then go forward with the trial. To start trial immediately would be, especially with a critical witness, it would likely be a waste of judicial resources, a waste of, and the danger of having double jeopardy being invoked at that point.
Yeah, thank you.
Ms. Karamy, are you proposing that having a subpoenaed witness you said it completely satisfies due diligence? Are you saying that if you have a witness that you've subpoenaed not show up for trial, that you are automatically entitled to a continuance of that trial?
I wouldn't say that, Your Honor, and I'm aware here that it's an abuse of discretion standard. I'd say that when faced with those facts, it very likely rises to an abuse of discretion, but that's why I argue that the court in this case should have looked at other factors, including the reasonable grounds to believe that a witness would appear. Part of those reasonable grounds are, one, the issuing of the subpoena, two, that the prosecution knew where the witness lived, where the witness worked, so that it was likely that with a bench warrant, the issuance of a bench warrant, that they would be able to find that witness, bring that witness in within the time left on speedy to have that trial. So I'm not arguing for a per se rule. I'm arguing that requirement of due diligence, which in all the cases addressing continuance, they always address the due diligence of the prosecution in making the witness available. There is nothing more that people could have done here other than perfect personal service. What the people did in advance of that was stay in contact with the victim as best as they could, which goes to that other ground, the reasonable grounds to believe that the victim can be made available. Although she's uncooperative, doesn't want to come in, they know where she is and how she can be found. In cooperation with the court, issuing a bench warrant, which it had little discretion there, that's also an abuse of discretion with the court when the prosecution requested a bench warrant, that the court didn't issue it.
Well, all of your requests for a bench warrant were in connection with asking for the continuance, weren't they? You never asked for just a bench warrant, full stop, we want that to go forward, right? I mean, it was always in connection with we want a bench warrant and the continuance.
Yes, sir. Otherwise, just asking for the bench warrant at that point, when it was a critical witness who was going to be, as the defense pointed out, likely the first witness in trial, wouldn't have been an effective use of the court's time of that rule.
Well, it could have been, given the circumstances that you asserted, which is we know where she lives and works. We've been in contact with her. One of our officers talked to her this morning. I mean, you basically told the court, look, we can't get her here in the next 10 minutes that you took a recess for, but that doesn't mean that we're not going to be able to get her. There was some reason to believe, given the extent of your contact with her, that by the time the jury was selected and seated, that you could have sent an officer out to, if the court immediately issued your warrant right there, you handed it to an officer, a deputy could have gone out and attempted to retrieve her and have her back. Now, it risks jeopardy attaching, but the court never refused to do that, right? I mean, you never made that request of the court. Fine, if you're not going to give us the continuance, we still want the bench warrant, right?
I'd argue that the court still needed to rule on that first request for a bench warrant. It shouldn't be on the onus of the people to repeatedly ask for something that the court isn't ruling on. The court, by implication of denying the motion to continue, also by implication denied the request for a bench warrant. And when that denial happened, the case was dismissed, and at that point, the case was closed.
Well, but to put it differently, you asked for the continuance, you were denied the continuance, a dismissal was requested which wasn't explicitly objected to by the prosecution. There was no bench warrant to issue once there's a dismissal. The bench warrant under the rules is only effected as long as there are charges pending. So had the court said, bench warrant granted, motion to dismiss granted, bench warrant vacated, we're not in any different position by virtue of having denied that bench warrant for the intervening 15 minutes while you were talking to the court, right?
I'm unsure in your example, Your Honor, where the people would have had room to re-request that the bench warrant issue when it was never, the initial request was never ruled on.
Are you saying, excuse me, I'm sorry to interrupt you, go ahead.
No, it's fine.
Are you saying that the people asked for a bench warrant first? Was that the first thing they did?
No. First they asked for a motion to continue,
okay,
and then they asked for a bench warrant, and I understand Judge Welling's interpretation that was in the same paragraph. So I understand the interpretation that was asked at the same time. But my position is that there really wasn't time for the prosecutor to re-raise that, especially when it wasn't initially ruled on whether the bench warrant would issue or not. And it really is, there's little discretion in Rule 17 for the trial court to deny and not issue that bench warrant. The language is the court shall issue the bench warrant upon request of the prosecutor.
So is it your position that it should have granted the bench warrant independent of its ruling on continuance?
Yes, Your Honor.
And how isn't, oh, I'm sorry.
If I could address that, if the court had to do that, then the prosecution would have been in the position of, look, we got to get this trial done. It would have risked double jeopardy, but at least the case would have continued. People had her under personal service and have a better chance.
Is that the people's position, that they would have rather had the opportunity to go forward with the bench warrant being issued and go forward at that time?
Yes, Your Honor.
Okay, now the next question is then, normally when you ask for something and it doesn't get ruled on, normally the party asking for something has to press the court for a ruling. Why should the people be excused of that here?
Normally, pressing the court for a ruling is really creating that record so that this court has more to rule on. So I'd argue that that fault here, if there is any fault, would be a limitation of the record. But I do argue that the record is sufficient and shows sufficient grounds, multiple grounds, that justify a continuance in this case. Not only the due diligence, but the reasonable likelihood that the witness could be served, and also the alternative, short of violating the defendant's speedy trial rights, that the trial could go forward within the 6 months.
How is the denial of the bench warrant a prejudicial error, independent of the denial of the continuance and the grant of the dismissal?
Because it relieves, the court's enforces a subpoena. The whole purpose of a subpoena is if a witness is reluctant, the court has that ability to force somebody to come in. So when the court doesn't rule on that, that tool of making a witness available is taken away from the prosecution. It puts the victim running the case as opposed to the court procedure.
Right, but the error was we should have been entitled to our bench warrant anyway. You also argue we should have been entitled to a continuance and the court erred in its dismissal. But the subpoena or the warrant should have issued, but then the court also denied your continuance and dismissed the case. So even if the court hadn't erred in denying your request for a warrant, that warrant would have evaporated as soon as the court dismissed the case. You're not prejudiced by not having a warrant for the 15 minutes that it was being discussed. The error in not issuing the warrant is either connected with not continuing the case or dismissing the case, isn't it? If there's any prejudice from that denial of the warrant.
Well, I would argue that the error is connected to not continuing the case.
Okay. Okay, so now we're back to whether or not the court erred in the denial of the continuance.
Yes, that's the central issue. That affects the dismissal. That affects part of the analysis for the abuse of discretion is that tool of executing the bench warrant, although it was asked for, it wasn't able to be effective.
And the rule that you laid out for abuse of discretion is you're essentially laying out the same rule that exists for tolling speedy trials for the unavailability of a witness. Does it look any different under these circumstances? And what would the rule that you're asking us to announce look like in this case?
The way it's different under these circumstances is that speedy trial issues aren't affected. So the abuse of discretion in weighing prejudice, particularly the prejudice of the defendant, in this case where the court made the finding the defendant had been in custody for a long time, that gets weighed against the people's due diligence efforts and the reasonable grounds that the witness could be available. And more weight is able to be put towards those efforts that people make to make the witness available because there is less of an impact on those speedy trial rights. Although the defendant is in custody for a while longer, there are other mitigating ways to avoid violating those speedy trial rights, such as the continuance, such as, even though it wasn't on the record in this case, reducing the bond so that the defendant has a better chance to be let out of custody. If the court has no further questions, then my time is pretty much up. Thank you.
Thank you, Counsel.
May it please the court, my name is Matthew Fredrickson, registration number 47453, and I represent appellee Mr. Floyd Sinnett. In this case, Mr. Sinnett pleaded not guilty to aggravated robbery and menacing on April 27th, 2016. His speedy trial was set to run on October 27th, 2016. He was set for trial on October 11th, 2017. On that date, the court is faced with two different actions, whether or not to grant a motion to continue, and then a dismissal of the charges against him in the face of an uncooperative witness. Your Honor, as I submit to the court in this case, that the prosecutor made her request to the court and the court ruled appropriately. The prosecutor mentioned the bench warrant and the motion to continue always in tandem. They were always a compound request. The prosecutor requested the motion to continue and the bench warrant if the victim did not show up. Then, in response to the court's questioning, what are we going to do if the victim isn't here? The prosecutor said, I'm going to ask for a motion to continue and the bench warrant. And then again, on the day of trial, the prosecutor asked to set the matter over and for a bench warrant. These were always compound requests. They were always together, and the court knew what the prosecutor was going to do if there was no continuance. It was not able to proceed. It said, quote, I cannot go forward without the victim present. Facing that, when the court exercised its broad discretion and denied the motion to continue, and the prosecutor did not go forward or request a bench warrant independent of that motion to continue, the court had no other choice but to dismiss the case. The prosecutor was not proceeding.
Counsel, let me ask a question on that. You said the continuance and the bench warrant were always mentioned in tandem by the people, and it was always denied in tandem, I assume. So let's assume that, which is what happened, the continuance was denied, the bench warrant was denied, correct?
No, Your Honor, the bench warrant was never explicitly denied, and I would agree with the court and the prosecutor that under Rule 17, The language is clear that the court shall issue the bench warrant versus the subpoena. What the court was doing was implicitly denying the motion to continue, saying we're going to decide this in about 15 minutes, and in those 15 minutes, the prosecutor had every right to request the bench warrant and the authority to ask for one.
And they did, didn't they?
No, Your Honor. In those 15 minutes, the prosecutor still asked for a motion to continue in the bench warrant, saying I cannot go forward without one.
So, what authority did the court rely upon in entering a dismissal of the charges against the defendant?
Yes, Your Honor. So the first rule that we have on dismissals is Rule 48 of the Colorado Rules of Criminal Procedure. And neither of those touch briefly at all on this kind of issue. What was happening here was the prosecutor was not proceeding to trial. It was not presenting evidence. It was not carrying its burden. And so with that, there was no case in front of the court or a jury, and the court dismissed the case.
Did the prosecution indicate that it was not going to proceed if it did not receive the continuance?
Yes, Your Honor. I would point the court to exactly page 2 on a very short record we have where the court said, I cannot go forward if she's not here that morning, because the prosecutor was requesting both in tandem and said, quote, I cannot go forward without her. And so it was submitting to the court that she would not be proceeding.
How could the prosecution go forward without her? How could they go forward without putting itself in danger of invoking jeopardy and a possible dismissal if they couldn't find her in time?
Your Honor, I begin by answering your question. I would begin in discussing that the prosecutor put on the record that she was not to testify until the following day in the afternoon on Wednesday. That was about 36 hours from when the trial would have started. That would have given them plenty of time, given what the prosecutor represented. We know exactly where she lives, where she works. We can get her here.
Why did she ask for 11 days then, if it was plenty of time?
That's a good question, Your Honor. Why was it 11 days? Why couldn't she proceed forward, which is what the rules anticipate? Because under the rule, Rule 17, the person is to be produced immediately in court, and that the warrant can expire at the conclusion of the trial. So the rule anticipates the trial going forward as planned. And that's what the rules require. So though it might be a concern with judicial resources, that's what the rules require. They are different actions, but the prosecutor never requested them independently. And so the court, knowing that they were never requested independently, ruled on what the prosecutor requested.
I want to go back to Judge Hawthorne's question about the authority for dismissal. You point to Rule 48, but that's a failure of proof, a motion for judgment of acquittal after the prosecution fails to prove their case. But that burden doesn't arise until the trial begins and they're afforded an opportunity. And they never said one way or the other whether they would proceed. So this wasn't a Rule 48 dismissal. So if we're not persuaded that this was a Rule 48 dismissal, what was the other authority of a trial court to dismiss a case pre-trial when concerns about procuring a witness have been expressed?
Your Honor, that's why I turn to the Gallagher case as a parallel to what's going on here, is the court is providing the prosecutor with a forum in which to present evidence. I would agree with the court that yes, that burden does not spring into being until the jury has been impaneled. But in this case, the rules anticipate going forward and a jury being impaneled when there is a motion when a bench warrant can spring into being as well.
But the court here never said, your motion for continuance is denied. Counsel, prosecution, it's on you. Let's go. It just said, well, I'm denying the continuance, so I'm also going to go ahead and dismiss the case. Instead of saying, we're going forward, do you still want your warrant? Do you, should we bring the jury upstairs? It just said, continuance denied, case dismissed.
Your Honor, I would disagree. I believe there was an intervening 10-15 minutes there where it was implied and quite clear that the prosecutor was not going to get his motion to continue. And in those minutes, in those 10-15 minutes, could have requested once again the bench warrant separate or independent of that motion to continue.
Yes.
And the onus was on the prosecutor. I apologize.
Excuse me, I'm sorry, I didn't mean to.
No.
But the court never said, prosecution, call your first witness.
Your Honor, that would not be the first step. The first step would definitely be getting the jury.
Well, be getting a jury, or I mean, we didn't get a jury. We didn't start a trial. We didn't say call your first witness. So how can the court dismiss? On what authority can the court dismiss the case other than there's been no witness called, you've taken no efforts to prove your case, Mr. Prosecutor? What's the authority for the judge dismissing without taking some of those steps?
Well, the defense moved for the dismissal with the prosecutor not proceeding in the case. And so the prosecutor was electing not to proceed without both the motion to continue and the bench warrant. And without proceeding, the prosecutor was essentially not using the tools at their disposal to be able to proceed with the bench warrant. And with the prosecutor who's not willing to proceed, what other choice does the court have than to dismiss the case? Yes, no jury had been impaneled, no requested to call your first witness, but the prosecutor wasn't electing to proceed. The prosecutor had told the court, I cannot go forward. And so it was electing not to proceed and present evidence. What more could the court have done other than dismiss the charges now that that motion to continue had been denied?
Let me posture this case a little bit differently. Had there been a denial of the motion to continue and the prosecution was in a position that the time allotted for jury selection wouldn't have been enough, but a week would have, and they could have proceeded, could the prosecution have voluntarily dismissed the case and then appealed the trial court's allegedly erroneous denial of the continuance, saying we were essentially forced to dismiss the case because we were wrongfully denied the continuance, and then taken the case on appeal?
Yes, Your Honor. I think that in that posture, if the prosecutor had elected to dismiss the case of their own volition, then the dismissal likely would have been without prejudice, and refiling could have happened if it was within, but that's not what the court has in front of it.
And that's different than my question about whether or not they could have dismissed without prejudice and refiled. Could they have appealed the denial of the motion to continue and the issuance of the bench warrant?
No. At that point, then it would have elected to have dismissed the case, and it could not have appealed that order, or that request. No.
Okay. Counsel, can I ask you about the ruling on the continuance itself? As I understand, the trial court's ruling was based on the prejudice to the defendant. What about the other factors? Isn't there a totality of circumstances test that applies here for determining whether a continuance would be appropriate? Don't some of those other factors, or most of those other factors, weigh in favor of granting it a continuance? How's that for 4 questions?
Your Honor, it is a totality of the circumstances test, and the court is looking at the whole panoply of different variables. And the court had in front of it the very factors that the prosecutor is putting on the record today and is arguing in the brief. All of the due diligence that had been done, and the court implicitly rejected those, and instead turned to the fact that it was unlikely that the witness would be cooperative and appear a week later, and the fact that Mr. Sinnett had been sitting 168 days in custody. And we aren't looking in the abuse of discretion standard at whether or not there was a better use of discretion, just whether or not there was an abuse of discretion. You're not making a value judgment. You're looking at whether or not any reasonable mind could find the way the trial court did.
Well, trial courts have a lot of, I'm sorry for interrupting, but they have a lot of discretion in ruling on and imposing sanctions, but when the consequence is dismissal, there is some exacting examination of the exercise of the discretion in a way that results in dismissal, to say, look, there were other things that you could have done that were less drastic than this that could have achieved the same end. And shouldn't the same, perhaps more careful study of what actually resulted occur here in determining whether or not there was an abuse of discretion?
Your Honor, I believe that there was a less severe alternative, and the prosecutor elected not to pursue it. You had mentioned in your questioning of the prosecutor that third alternative, which was to proceed and have the bench warrant issue in those 36 hours pending the bringing in of the witness. Does that?
Well, that's one, but what about the granting of the continuance and releasing your client on his own recognizance and issuing the bench warrant?
And again, Your Honor, I would submit to the court that the abuse of discretion standard isn't looking for better abuse of discretion. It's looking at whether or not there was an abuse of discretion. And under the Colorado Supreme Court case in Wilson, you're looking at whether or not a reasonable judge could reach the conclusion, or a reasonable mind could reach the conclusion that the trial judges did. And this trial judge, with all of the due diligence that the prosecutor put on the record, was still unable to get the complaining witness into court. And the court found that it was unlikely that this witness would be cooperative and would actually be brought into court. And that is a reasonable conclusion, given how all of this due diligence did not, in fact, bring this witness into court.
Any indication that the analysis of that due diligence considered the usefulness of a bench warrant? Because the prosecution doesn't have that tool at their disposal until the witness fails to appear. And it doesn't look from this record that the court, in making that determination of the likelihood of the continuance resulting in a different result, considered the additional tool of an active bench warrant.
Your Honor, that was not in front of this court. This court had in front of it a motion to continue tied to a bench warrant. And so when it knew that the motion to continue, or that proceeding was contingent on both, and denied the motion to continue, you suddenly had a prosecutor that was not proceeding forward. And no independent request for the bench warrant. If that had been in front of the court, yes, under Rule 17, the court was required to issue it.
No, I'm talking about in analyzing the denial of the motion to continue. It did have a request for a bench warrant in front of it. And in determining whether or not the continuance would be of any benefit, the trial court didn't seem to give consideration to the fact that there would be an active bench warrant during the intervening period of the continuance.
But then, Your Honor, you also have at the same time 11 days, or 7 days for the week continuance versus the 36 hours. The 36 hours was what the prosecutor had to get her there with the bench warrant. And so the court had, well, the prosecutor represented to the court, I'll meet her next Wednesday, or tomorrow afternoon. That was 36 hours from the impaneling of any juror and the start of the trial.
But had the court granted the continuance and the bench warrant would have remained active until the defendants picked up or the morning of the continuance. It doesn't expire at 36 hours.
It does not, no, Your Honor. It expires under 17H2A at the submission of the evidence to the jury, or at the same time the dismissal or the conclusion of the charges. So yes, that tool would have existed, but it was always tethered to the motion to continue. And when the prosecutor did not elect to separate that and present that option to the court, she was not proceeding, and suddenly there was no case in front of the court, and it had no other choice but to dismiss. If there are no further questions, I would ask that this court affirm the rulings of the trial court, the motion to continue being within its broadest use of discretion, and the motion to dismiss when there was no case in front of a trial or jury. Thank you.
Thank you, counsel. Case will stand submitted, and an opinion will issue in due course. I want to thank counsel for their fine arguments and briefing on this case, as well as your willingness to participate in this program. As I said earlier, this program only works when we also have lawyers that are willing to make the sacrifice and participate. And I think you did a very able job of showing the students here some very good arguments on both sides, and we appreciate your arguments as well as your briefing. With that, we will stand in recess.
All rise. Court will be in recess.
Okay, ladies and gentlemen, we'll run this the same way we ran the last question and answer period. If I could get Ms. Karimi and Ms. Erica, thank you, Mr. Fredrickson, to share this microphone. Once again, please fire away. Any questions? Well, let me get the ball rolling a little bit. I think we touched on this a little bit with the attorneys for the first case. Most often in a criminal case, the attorneys on the appeal did not handle the trial. So could you explain a little bit about how it's different to pick up a case at that point than to stick with it all the way through?
Sure. So I also got assigned my case. I was not with Mr. Sinnett in the lower court, but I have done some trial work, and so picking it up at that stage, you're always cognizant about what's going to be seen in the higher court and what should be objected to and preserved for this court to be able to review it. So you want as full a record as possible. Even though you're trying to win at the trial court level, you also have to be aware of the fact that it could go against you, and you want as much meat there as possible to present to the appellate court.
I'm in a slightly different position. I'm actually a prosecutor, so the woman who prosecuted this case is a colleague of mine. I'm in the appellate unit at my DA's office, so this case was assigned to me, but I'm familiar with the prosecutor. I'm familiar with this growing habit within my jurisdiction of dismissing cases when we ask for continuance and have personal service. So for me, I had a little more contact with it than your average appellate attorney since I knew the parties, and I've also had Mr. Sinnett subpoenaed as a witness in other cases. So.
Thank you again for coming to Silver Creek High School and participating in this courts in the community. This is the same question I would have asked the first panel of attorneys. Assuming there's a one party would like to further appeal this Court of Appeals record, do you represent the parties when assuming there's a further appeal to the Colorado Supreme Court? Are different attorneys assigned for the Supreme Court hearings, or do you stay with the case for the next appeal?
In my office, I'd stay with the case.
And for the Office of Alternative Defense Counsel, I would stay with the case, yes. Alternative defense counsel is when the public defender has a conflict and they contract out to those of us who are in private work, and so I'm kind of both private and state employed.
A little follow-up, if I may. When you do appear in the Supreme Court following your appellate work at the Court of Appeals here, is there a difference in terms of how you prepare, how you present? Do you change do you discover and learn of different arguments or different points to make based on the record here?
Oh yes, this is such a great opportunity because you know exactly what the court is thinking about and what questions they have and what they think are the main legal issues, and that helps frame what the Supreme Court might be interested in. The Supreme Court is kind of a policy court in that they take important questions that need to be ruled upon, and so if you can get a nugget of some information that the court is saying, I'm struggling with this aspect, that might lead to a published opinion, that might lead to a dissent in the opinion, and then that would be very attractive to the Supreme Court, but they could also hit on a gray area of law that the Supreme Court hasn't dealt with, and that would make for my cert petition to the Supreme Court.
This would assume that they take cert to go to the Supreme Court.
Yes, so they take a fraction of cert petitions in front of the Supreme Court, and so you're trying to make it as interesting and attractive as possible to them.
This is a question directed to Mr. Fredrickson. Yes. When you referenced the other case, the Gallagher case, is that to strengthen the argument you're making to the judges?
Yes, so I couldn't find a case that paralleled this exactly, but in 1988, Gallagher versus County Court, they did have a similar situation where the prosecutor was not able to go forward at a preliminary hearing, and that's where the court is deciding probable cause, whether or not the case can go even further. Probable cause is like a lower barrier to beyond a reasonable doubt, which is the conviction barrier, and when the prosecutor didn't use its forum to prove to the court that there was probable cause, the court could dismiss the case. The court was empowered to dismiss the case.
Okay.
So I use that as kind of an illusion parallel to say, hey, look at this other reasoning to try to help my argument. Yeah. So.
Okay, thank you. And also, it was said totality of circumstance. Is that correct? What does that mean?
Yeah, so it's the court looking at all the different things that are going on, all of the different factors. So for a motion to continue, they're looking at their docket schedule and whether or not there are a lot of other cases going forward. We know in this case we had the following week, there were 5 more trials set for that following week. Some were likely to go, some were not likely to go. And so the court is considering that. The court is considering the position of the witness. The court is considering the position of the defendant who was in custody for 168 days, considering whether or not there's priority. I mean, it's all the things that the court is considering. So, yeah.
Thank you.
So, while you guys were presenting your arguments, I just couldn't help but notice how imposing and almost intimidating the characters of our judges here today were. Is that something you ever get used to, being questioned by such powerful characters, or is it just something that sort of sticks with you through your entire career?
I'll say this, before every trial, before every oral argument, I'm nervous. No matter who the judges are, no matter who the judge is. And you just learn to live with that. If you play sports, sometimes before you start a game, you're nervous, and I played sports, so that energizes me. So it's nothing that I carry over as being intimidated for a long time. Now maybe you have a particular run-in with a judge, and that might stay with you for a while. But in general, really, I look forward to arguing before a judge. because the back and forth, once you get over those nerves, you think about your position and the issues, and you really enjoy engaging on those.
Yeah, I did a lot of drama in high school, and so you kind of think about the darkness out here and how imposing that can be. And these judges aren't terribly scary. They're just trying to figure things out. They're not going to hurt you. They're not going to attack you. So I think if you just think about it like someone who's trying to understand, who's trying to get you, trying to get your position, it's a lot easier. But it is nerve-wracking. There have been, when I used to do trials too, I used to throw up before trials, and it was not the best experience. But there it is, so yeah.
Thank you. As something that I want to ask was, have you ever done this kind of in front of a school before, where you fought your case in front of a school or in front of somewhere other than a courtroom? Kind of more of a larger audience?
It's a good question. I have not, no.
I have not, and I'll tell you a secret, this was my first oral argument, so.
I guess a follow-up to that would be, with this being your first oral argument, and it being in front of a larger audience than you're used to in a normal courtroom, were your nerves a little bit higher today? And I guess this applies for both the lawyers here. If your nerves are a bit higher and that you're a bit more, I wouldn't say scared, but maybe anxious to come on stage?
They were higher because just wanted to make sure I got the little things right. Because when you practice a lot, I know in trial there are things I know how to do automatically because I've done more trials than I've done oral arguments right now. As for you guys, to be honest, I ignored you. Oh, but I did, when I was getting ready, I made sure that the back of my head looked good for you, so I did do that.
Don't worry, man, the teachers usually do that as well.
Pardon?
Nothing.
But really, any argument I do, even when I'm in court, arguing in front of one judge and there is a gallery behind me, I'm really focused on my argument, so everything drops away and you're really focused on your argument.
Yeah, I think that's, when I was a public defender and you had your client right there, I was really worried about him or her, but for the most part, no. I don't think this was any more anxiety-ridden.
Thank you.
Hi. You guys said that you guys have both worked trials, so is it hard to, when you move into like the appellant kind of situation, to focus more on what the court's doing wrong versus the person, like if they were guilty or not, versus the court was guilty?
I'd say it's easier, maybe because I'm a bit of a law nerd. I like to focus on the law, which is why appeals is a really good fit for me. When you're arguing facts in front of a jury, you've got 12 people that you don't know. These judges, before I came, I reviewed opinions they wrote, arguments they'd done before, so I could do my homework on them. The difference with trial is you've got 12 people who have never met each other, you don't know about them, and you're educating them on facts. So that's a big difference, trial and oral argument-wise.
As someone who's had a defendant, I'll echo what the public defender said this before me. We never really think about whether or not they're guilty. Our main focus is making sure it's fair for them and that they can return to a life afterwards, because life doesn't stop with that instance. We're not who we are on our worst days. So I never think about that. It is more fun to tell a judge that he's done something wrong. That is a lot more fun. because usually the odds are against the defense. So.
What's good? So basically, I have a friend that got arrested for breaking and entering recently, and so I was just kind of curious. Do you defend like minors often?
So, I have done maybe 3 juvie cases. It's really, I've got a good colleague who specializes in juvie cases. So yeah, I would hope for the best for your friend. Don't talk about it at all. Don't talk about it at all with anyone. Okay.
Thanks.
Thank you, counsel. Thank you very much for that. Thanks for the great questions, Joe. The judges will be back out in just a couple of minutes, probably less than that. So I hope you've been thinking about questions for the judges as well. And they'll be out very soon.
My name is Craig Welling. We've got Bob Hawthorne and John Daly, all judges on the Court of Appeals. I think this is question and answer, is that right? With the big ground rule being nothing about the cases that we just heard argued. So that's the one area that's completely off limits. But otherwise, have at it. Have at it.
Microphone's really high. Okay. Hi. My question was, as judges, what is the part of the Constitution that you feel really prohibits or inhibits the judicial system, if any?
Inhibits the judicial system?
Yeah. Do you feel that any parts of the Constitution do that?
Have you been studying Marbury versus Madison?
I love that court case.
Of course you have. I was going to say, are you trying to suggest that there are no restrictions on the judiciary? Is that, yeah, okay, that's what I thought you were suggesting. Well, actually, there are restrictions on the judiciary, the other 2 branches of government. Although the judiciary pretends to have or purports to have the final say with respect to, determining what the law is, there's still a funding mechanism. And there's still a executive department as far as implementing the decisions of the court. One of the things we've been blessed with in this country is some very controversial decisions out of the United States Supreme Court that the executive, the president, especially back in the 50s and 60s, stood right behind the judiciary in enforcing those orders rather than saying, as Andy Jackson may have done in the 19th century, the Supreme Court has made its ruling, let it enforce its ruling. So I didn't answer your question.
I was wondering what it takes to become a judge.
Pardon?
I was wondering what it takes to become a judge.
Well, I think what you'd notice on our court is there's 22 judges and 22 paths to getting there. I think maybe this might be a chance to have each of us tell you a little bit about the path that we followed as opposed to any magic recipe for that.
Well, of course, you have to go to college and you have to go through law school. That's going to take you about 7 years, college and law school.
It took me 9.
It took me longer than that too, with military intervening. But after you get out of law school, then there are lots of different paths that attorneys may take. You may work for the government as some sort of a government interest attorney, private practice. You may be in-house to some large corporation. Judge Welling said we probably represent 3 different paths right here, and you'll see 19 others on our court with the other 19 judges. I went into private, well, I started out with the prosecutor's office in Springfield, Missouri. So I was a prosecutor, and then I went into private practice. I practiced law, general practice, a little bit of everything, including criminal defense and including civil litigation for about 30 years in a small town of Lyman, Colorado. And I had a general practice out there, and then I applied for the court. Been on the court now 13 years. In order to apply to be a judge, you have to have 5 years of practice of law in the state of Colorado. That's the minimum. I have to say that probably very difficult to be appointed a judge with just 5 years of practice.
And for me, I went through law school, as I said. I had a more scenic route through college and law school. I crammed 4 years of education into 6 in undergrad. I highly recommend it, much to your parents' chagrin. But and then took a little bit of a break and went to law school, and eventually went into a private civil practice. So it was people suing each other over money. I left that practice to go work as legal counsel to Governor Ritter. And so I worked for 4 years as the governor's lawyer, and then applied to and got appointed to the district court bench about 7 years ago. And so I was a district court judge for 7 years before coming on or for 6 years before coming on to the Court of Appeals.
I had worked for the Attorney General's office for about 21 years before I was appointed to the Court of Appeals. What I'm about to tell you can be taken one of 2 different ways. We have a merit selection system in Colorado, whereas if there's a vacancy for a position, you apply for it. A committee, a nonpartisan committee, screens you for determining whether or not you should be sent on to the governor. The governor sends on 3 names. I'm sorry, the committee sends on 3 names. The governor picks one of those 3. Here's the point that you can take either way. I think my wife and I tried about 17 different times before I made it out of that committee and to the governor's office. You can say that's persistence. You can say maybe there's a reason why you weren't selected 16 other times.
Does that answer?
Yeah, thank you.
All right, thank you.
Hi, I was just wondering, how are you selected to hear these cases out of like your entire panel of judges?
That's a good question. Our clerk's office actually worked really, really hard to try and identify cases that would be of some interest, as well as cases that were ready to be heard about this time. Also had lawyers that were willing to travel. And they picked out some cases, circulated among us, we reviewed them, then we reached out to the lawyers. Some of them said, no, we're not willing to do it. Other cases, it just wasn't postured right. So it was, the work was really done by the clerk's office, and our group of staff, attorneys and lawyers that work in our clerk's office of trying to identify cases and then do the work of reaching out to the lawyers and getting them all prepared. So we really had very little work to do in this, but it was really the laboring oar was carried by them, and a lot of discussions about what could potentially be of interest.
Your Honor, I think she was asking how the 3 of you got to come to this school.
Oh, how the 3 of us got to come to this school. We're lucky. This is my first roadshow. Both of my colleagues have done this many, many times. Since we were going to be in Boulder, each of the judges on the Court of Appeals, all 22 of us, are assigned a specific judicial district. There just happen to be 22 judicial districts across the state and 22 judges. My judicial district happens to be Boulder. And since we were going to do courts in the community in Boulder, I think it was decided that the judge whose judicial district is Boulder should be on the panel that does it. And these were the 2 judges I was on the panel with. So because this is my district, I was going to get to come and I happened to be sitting with these two fine judges at that time. So, because we really do try and do some outreach into the districts that we're assigned to, and I'm lucky enough to be in the fighting 20th. So, yeah.
The first part of your question that Judge Welling thought you were asking about how do these cases get assigned to us, and he went through that, but I just wanted to point out that you heard the backgrounds that the three of us have. In the assignment of cases to divisions and to judges in the Court of Appeals, your background, the judge's background, has nothing at all to do with the assignment of cases. The Intermediate Appellate Court in the state of Colorado, which is the Court of Appeals, hears appeals as a matter of right. If someone files an appeal and we have jurisdiction, we have to hear it. We will hear it, whatever it is, except for two things, maybe three things. There are three things that we do not hear and do not have jurisdiction to hear. One is the death penalty, anything regarding capital cases, capital punishment. We do not hear, although we hear every other kind of criminal case and part of a criminal case there is. Two is water law, so you can see how important water is in the state of Colorado. It's on equal footing with capital punishment. And three is appeals from the Public Utilities Commission. We don't hear those appeals, but everything else we hear. Any kind of case you want to think about. Judge Daly was with the Attorney General's office, so his background was in criminal law. And Judge Welling said he was in civil practice. I was in civil and criminal, but we get domestic cases, we get DNN, termination, contract cases, real estate cases, anything you can think about that might come before the court, that's what we hear. And it's assigned randomly. That was my point in the first place. It's assigned randomly through the clerk's office. It has nothing to do with who we are or what our background is.
The death penalty, the Public Utilities Commission, and the water law cases, they are heard. They go to the state Supreme Court.
Hi. I was just wondering how, if at all, your morals come into effect when deciding on a final verdict, and also how your personal opinions, how you keep your personal opinions from affecting your decision.
That's a great question. I don't think there's any way that you can totally divorce yourself from who you are and what your personality is, where you come from, what your perspectives are. But to the extent you can make yourself conscious of them and be aware of them, so that when you confront a case with briefs and you have to read the statutes, you read the case law, so that you do not allow your biases to come through, you're better off doing that. So, you know, if there's a legislative choice been made, unless it's unconstitutional, our personal preferences really shouldn't play and hopefully don't play any part in our decisions. Sometimes we do have different perspectives based on our experiences when we come to the cases, but that's sometimes also the benefit of a multi-judge court, that we get the benefit of each of our experiences as we try to hash out some of these decisions.
That's a great question, and it's also one of the beauties of being an intermediate appellate court is we are not, free-roving doers of justice. We are constrained first and foremost by the Constitution, then by the legislature, and then by our precedent. And that helps us stay in those lines and figure out how we apply the law. But something that we all have to be aware of is our own implicit bias. I mean, the most dangerous biases that you carry are those that you may not even be aware of. And it is, I think, a struggle to make sure that you remain aware of those and constantly ask yourself that question of, am I basing this on the law and what I am supposed to do, or is there something else creeping in?
I think Judge Welling and Judge Daly have answered that question very well, but related to that is a question that we often hear of how politics plays into our decisions. And I have to tell you, I've been on the Court of Appeals for 13 years now, and I know Judge Daly is longer than that, but in that period of time, I have no idea what my colleagues' political persuasions are. Personal, political feelings or thoughts never, ever come into our discussions or our considerations of a case. And everything else that Judge Daly and Judge Welling have said, I endorse.
All right, so obviously there's a certain amount of professionalism involved in court, right? You can't like go dressed as I am.
Well, we could. We wear a robe.
Yeah, that's at least my question. So when you guys came up here, I did notice. I have no idea what it's like to be a judge. I have no idea what the rules are. So I was wondering if like you had to wear the same color like suit.
Yeah, we shared an email this morning.
I'm so proud of you. All right, that's it.
Do they match?
Thank you so much.
Thank you.
I was curious if courts vary state to state or perhaps civic to military at all, or is it just sort of universal across the country?
Hugely. I think, and I want to harken back to one of the things that Judge Daly said, and I think it begins with how judges are selected across the country. Some states have an elected judiciary, and there's a whole variety of ways that you can pick a court and organize it. And I think the way that a state chooses to select its judges has a considerable impact on how functional a court is, how it does its work, as well as how effective it potentially is. And that is all over the map across the country. One of the things I had the privilege to do after getting appointed was go to a baby appellate judge school, which is for appellate judges that have been appointed within the last year or two. And I got to meet a lot of judges from across the country that are in different systems dealing with some different issues, a lot of them going back to how judges are selected and retained. That I think we've got a pretty darn good system here. Anything else to add?
Thank you.
Good afternoon. Before we begin, I'd like to thank both the judges as well as the attorneys who heard cases today. It's truly been an enlightening experience for me. I have a two-part question. First of all, what is the biggest difference between serving as a judge and serving as an attorney in your experience? And second, which character traits are indicate an aptitude to one of the two fields?
Let me go to the first part. Would you repeat that question, please?
Yes, my apologies. The first question is, what's the biggest difference between serving as a judge and as an attorney?
The biggest difference between serving as a judge and an attorney is that as an attorney, you are advocating for one side or the other. As you saw here today, there was counsel for the appellant and there was counsel for the appellee. And so as an attorney, you have a client for whom you are going to advocate and you are going to argue. And you're going to try to convince the court, whether it be in trial or in an appellate court, of your client's side of the argument. And that could be very differing between those two sides, as you could see. As a judge, we are not advocating for either side. As a judge, we are looking for what we think is the correct answer, or at least the best answer, to those disputed issues between the parties. And that really gives you personally a sense of freedom, I think, and a sense of trying to find out what the right answer is, trying to do the right thing by looking at the law and how does the applicable law apply to the facts of the situation that are before us without being tied to one side of that argument or the other.
I would concur in what Judge Hawthorne has to say. I think the biggest difference between the lawyer and judge is when you're the lawyer, you know where your client wants to go. So you build the bridge to make an argument to that result. When you're a judge, you don't know where the case is going to go. You try to decide it consistent with the law, fairly and impartially. I'm not sure it gives freedom as much as a sense of responsibility. I would say it might be a sense of adventure, though. Where is that law going? Where are we going on this case?
I guess the word I would use is liberating. I often like my seat much better than the hot seat that the lawyers are on. I think they have the really very, very difficult job in the courtroom. First of all, we're the ones asking the questions, and they just got to flow with it, which is pretty hard. Pretty hard 15 minutes at the podium. But even more so, I think probably both of these gentlemen have had this experience. Is sometimes I've gone into making a decision and trying to write it up, and it won't write. I think this is going to be the outcome, and because that's one of the things we have to do, is not just decide cases, but explain why we decide cases. And sometimes your outcome won't write. As a judge, we have the liberty to just go that other direction. As an advocate, you have the obligation to maybe try and find a better argument. I mean, you have ethical boundaries within which you can marshal forward those arguments if they're inconsistent with the law, but you are advocating for one side, and I find that experience liberating, I think is where I would go, but fraught with a great deal of responsibility.
Thank you. Yes. The second part of my question was focusing on what skills and personality traits you believe, having served both as attorneys and on the bench, indicates an aptitude for either a career as a judge or as an attorney in terms of the more successful option for you.
Character traits for both attorney and judge. I think they run the gamut. I don't think that there is really a recipe for who's drawn into either career. I think as an attorney, first of all, the notion that you need to be able to argue well or not be conflict adverse isn't true. The amount of things that you can do with a law degree and the opportunities that are available to you with a law degree to serve the public outside of just litigation is all over the map. And if I had to put one character trait for a good judge, it really at the end of the day goes to temperament.
This may be too simplistic. I once had a friend tell me that one of his father's favorite sayings was, "Two qualities you measure a person by are character and intelligence, and in the end, only character matters."
So we as like a class, and probably most of these classes have been like studying different types of roles in the judicial system. And one of the common themes that we've kind of seen is that justice is tiring. And I was wondering, do you agree, or what is your opinion on that?
Justice is tiring. Go for it.
Well, my first comment, or my first thought would be to describe to you what our caseload is like. And to be physically tiring sometimes. I know this is a very young crowd. We get, as I mentioned, we get cases assigned to us randomly. And we get essentially 13 cases every 2 weeks. And then we get other cases, emergency mental health cases, emergency child type cases that involve children that are dropped on top of that 12 or 13 cases every 2 weeks. And some of those can be very complex, some of them can be simpler than the others, but they keep coming, no matter how difficult or how simple they are. And if you don't finish those and get them done, the next docket comes in. So I need to ask you, I always explain to people what our caseload is like by referring to an old TV show by the name of I Love Lucy. You guys, I know you're all very young. I Love Lucy. Some of you know that. And do you remember the episode where Lucy and Ethel were in the candy factory, and their job was to box the candy, and the candy came out on a conveyor belt, and it just kept coming and coming, and they're boxing the candy, and they had a hard time keeping up with the conveyor belt. That gets a little tiring sometimes.
I think individual components of our work can be tiring. Justice is tiring. Sometimes I may be inferring too much, but sometimes I think that societally people look and say, well, politics is entering judging, and judging is not the way it used to be or should be. I would suggest that's a skeptical view. I would suggest that the country is still, when you look around, it still runs on the rule of law, and a rule of law that is still enforced and believed in by this country. And I don't think justice is tiring in that respect.
So I was wondering, when it comes to court ruling of like a defendant, are you ever, like, do you ever put in perspective like how it may affect their life and how it may affect the defendant's family's lives and like their friends and people around them?
Thank you. It's a really good question. I was a trial judge for 6 years, and in that role I spent my last 2 years on the trial court bench doing exclusively adult felony, and then before that I was doing juveniles who were accused of committing crimes. And without question, as a trial court judge, you have a great deal of discretion in deciding what sentence to impose for a crime, and there's a lot of things that you have to balance. The victim's rights and considerations, the harm to society, protecting society, but also the defendant, the possibility of rehabilitation. Are there programs that you can put in place that will get this person to be a productive member of society, as well as the collateral impacts on family? I mean, at the end of the day, it was the defendant's choices that are imposing those consequences on the family, but oftentimes there's also issues of mental health, of addiction, and all of those go into the mix. And that's why the decisions that the trial court judges are making are very, very weighty decisions. And I think we are really reviewing whether or not the trial court has acted within their very, very broad discretion to properly make those decisions and apply the law. And aren't in a position to second guess would we have imposed that sentence if we were sitting there as the trial court judge. Instead, we really look at whether they followed the law, sentenced within the range, made the appropriate findings, but not necessarily go back and revisit, is this the sentence? Have we been in that very difficult position? So in that respect, I find this chair a lot more comfortable than the chair on the trial court. Those are weighty, weighty decisions that our trial courts are making every single day that affect real people's real lives, and not just the defendant, not just the victim, but they have long-ranging ripple effects.
We have to be aware that our decisions affect people and have consequences on people as well. But I agree with Judge Welling that it's not the same kind of direct consequences a trial court judge ruling has. Sentencing is one of the most difficult things, I'm told, one of the most difficult things an individual can do, because you're weighing so many different circumstances and you're really affecting somebody else's life. But the same thing goes for dependency and neglect proceedings, the same thing goes for termination of parental rights proceedings, same thing goes for presiding over civil suits involving property, dissolution of marriage. Everything that's getting decided in the trial courts has a tremendous effect on individuals. We are filtered from it, but our decisions to affirm or reverse still has some effect on them.
Thank you. I want to thank everybody for their time and attention today. It was our honor and pleasure to be able to preside over these cases that you heard argued today. So thank you very much.
Thank you very much for sharing the experience with our students today. And students, I want to thank all of you for the professionalism that you exhibited
throughout our proceedings this morning. We're going to release you. Lunch is still going to stay within the normal time. That being said, Grand Certs classes, you may depart at this time.